speaker, Rod Kight. So Rod has joined us to discuss cannabis in cars, the scientific and legal issues raised by driving in cannabis. Rod is a cannabis business law attorney who represents legal cannabis businesses throughout the world. He is a prolific author, serving as editor-in-chief writer of the Kight on Cannabis Law blog, contributing legal perspective to the American Journal of Endocannabinoid Medicine, and publishing the book Cannabis Business Law, What You Need to Know in 2015. He's frequently interviewed on cannabis matters by major media outlets, including the Wall Street Journal, Time, Business Insider, and Business Insurance. Rod is an attorney advocate for NORML. He's also a member of the International Cannabis Bar Association, the National Cannabis Industry Association, Women Grow, the Hemp Industries Association, and the North Carolina Industrial Hemp Association. Rod has been a presenter on cannabis legal issues at seminars across the country, and he has also drafted and presented cannabis legislation to a foreign head of state. So really looking forward to hearing Rod's perspectives and what he's going to share with us today. So before we get to that, some announcements from CANN. So we hold this journal club at the end of every month. The next one will be on July 29th with Shannon Swantek, who is a quality specialist, and she will be speaking about cannabis supply chain best practices, adding value, and controlling risk. Other announcements, the El Soli Award, which is an award that CANN gives once a year to people doing research in the cannabis space and promotes them to come to CANN meetings and present their work. So that application for this year is due actually tomorrow. So for folks who are watching who may still want to submit, there is that open. Finally, we have 6 CANN sessions coming up at the ACS Fall National Meeting, August 17th to 20th. That is a fully virtual meeting this year, so folks can join from anywhere, and there is a reduced registration fee compared to the usual in-person meeting. So registration opens soon. I won't read all these off, but you can see we have 6 very interesting sessions for folks to attend. So look out on CANN social media and ACS social media for more about that coming soon. Finally, as always, we encourage you to join CANN today to keep up with what's going on in the cannabis chemistry science industry. Finally, I would like to thank our current sponsors. So platinum sponsors are Hydolph North America, as well as Carbon Chemistry. Our gold sponsor, CFS Consulting from our friend Jerry King. And finally, thanks to Perkin-Elmer, our silver sponsor. Perkin-Elmer has your turnkey cannabis solution. So with that, I'd like to take a few minutes in the beginning of these journal clubs. We like the audience to get to know our speaker a little bit. So Rod, are you there? Is your sound working?
I'm good. I'm here. Thanks for having me.
Absolutely, Rod. Great to have you. And I just wanted to open it up so the audience could get to know you a little bit. So you had shared with me previously that you actually had a personal experience that brought you into the cannabis realm professionally. Can you share a little bit about that personal experience?
Yeah, sure. So I've always been someone who believed that cannabis should be legal, certainly from a civil libertarian standpoint, but I never really believed in it as medicine until I tried it. I had testicular cancer about 10 years ago, and while I was taking chemotherapy, during the first phase of it, I was feeling, really bad, as one does when you're taking chemotherapy. I was achy and had sort of that cold flu-like symptoms. I was very nauseated, couldn't sleep very well. And so just on a whim, I thought, well, I'll try cannabis. I'd heard that it helped, and it certainly couldn't hurt. I wasn't expecting anything, and it was amazing how much it transformed the way that I felt. It helped me to the nausea subsided. My aches and pains were reduced significantly. I was able to sleep, and that sleep helped me to get rest so that I could, be strong for further chemotherapy treatments and so on and so forth. So it really changed my whole mindset about cannabis as a medicine and not just a Trojan horse for full legalization, which I'm in favor of. But in any event, that experience changed my law practice. I've done a lot of litigation, commercial law, bankruptcy, and all transactional work. And I decided that I really wanted and felt passionate about getting involved in the cannabis industry. And so I shifted my entire practice over. And so now it's about as close to 100% cannabis as a lawyer can be. You always have some, some family member or friend that needs a will or has a question about X, Y, or Z, but we're 99.5% or so cannabis based. And that is all directly out of my personal experience and my passion for the plant and my belief that it should be legalized and people should have access to it.
Well, thank you for sharing that personal aspect of your journey, and we're very happy to have you with us, of course, and having benefited from the plant and moved through your battle of cancer. So happy to have you with us, and really, really interesting. I know that there's a lot of folks who have similar stories and that do believe cannabis is medicine. So, and I'm one of them. So anyways, the next thing that I just wanted to ask you about is you were talking about how you got full blown into cannabis. And during that time, you actually wrote a book because there was not information out there for people such as yourself trying to get into cannabis professionally as a lawyer. So you wanted to actually help and educate other folks. Can you share a little bit about that experience and what your book's about?
Yeah, sure. So in 2015, I published, or actually Aspetor, which is a division of Thompson West, a legal publishing group, published my book, Cannabis Business Law, What You Need to Know. And as you said, it was the result of there not being, at least at the time, a good resource for lawyers and for business people as well, people who wanted to get into the business and wanted to know the legal lay of the land. So when I decided I wanted to practice cannabis business law, I immediately went online and searched around for what we call a horn book in legal circles, which is just if you want to learn tax law or workers' compensation or whatever, there's all sorts of books, and you can go and get an overview of the major cases and statutes and how it works. And that just didn't exist with cannabis. So I had to pull from all sorts of different places online, from cases in California, involving maybe tax issues, to looking at different sort of legislative frameworks that states had put up, and international laws, and kind of compiled it all together to create that book that describes the lay of the land. And I'm happy to say, or maybe I should be sad to say, because things haven't moved as quickly as they should have, the book still remains relevant, certainly on a meta level, as far as what types of issues that lawyers and business people should be thinking about. I'm sad that it remains relevant, because I think a lot of those issues should have been resolved by Congress a long time ago. But in any event, I did publish that book, and after that started my Kight on Cannabis legal blog, where I take an issue, often a novel issue, because cannabis law has so many novel issues, and analyze it. And even if it's not a novel issue, I like to provide an in-depth analysis so that people who read it actually get something from it and come away with an understanding of the issue, versus just some sort of a light dip marketing type of a blog. We really try to provide helpful information.
Understood. And it's interesting. I actually was going to ask you, does the book hold up today? And your response is really interesting about why it holds up. So I think a lot of us appreciate that. And yeah, definitely look forward to checking out your blog in the future. So another question I wanted to ask is that you mentioned that you work actually mostly in hemp, and that's allowed you to work globally and not just with CBD that a lot of people would associate with hemp, but with some of these other cannabinoids, because in fact, it's often THC that's the issue, and other minor cannabinoids, maybe CBG or maybe some of these other ones, you are able to work with. So can you speak a little bit to that, about your breadth of experience globally and beyond THC?
Yeah, sure. So a lot of our clients are in the hemp and CBD sector, and that was a little bit of a fluke. I won't go into too much detail because I want to stay on point with your question. But I personally live in North Carolina, which is a prohibition state for cannabis. And so when I first started practicing cannabis law, I struggled to find my where I fit in. Was I going to be representing grows and dispensaries in Oregon, where I have a license as well? I'm doing that long distance. But it was about the same time that the 2014 Farm Bill, which legalized a form of cannabis called industrial hemp for the first time in almost 100 years. And my home state and a lot of southern states that are prohibition states adopted industrial hemp pilot programs. And from that arose, the CBD market, as we know, because CBD that's derived from hemp is lawful. And I worked really hard on developing the source rule, which informs that and the CBD legal status. And so while we represent clients in all aspects of cannabis, including THC sectors, hemp is a big focus for us. And to your point, what that's allowed us to do is to focus on some of these more novel or minor cannabinoids, as they're called, because cannabinoids that are derived from hemp are not controlled substances. And so they can be transported and sold and marketed and everything else throughout the United States, and in very in some situations into different countries. So for right now, there's one of the things we're really working on with clients is applying for novel food approval with the EU for CBD, which has been named or classified, I should say, as a novel food. And so you have to have approval in order to market it. Also dealing with some growers in South America and getting their products to the EU and to the United States. So it's really fascinating. And it's exciting that this has become a global industry, and we're certainly representing clients all over the globe, helping them to bring their products to market.
Absolutely. And just one follow-up, I'm curious off that question before we move to the presentation. What do you see, if anything, as an upcoming trend in that space? You've talked about some countries shipping to other countries and stuff like that. So I'm just curious if there was one or two major trends you might highlight that people should be looking out for.
Yeah, good question. Well, I think that the sort of minor novel cannabinoids trend is going to be big. So medical cannabis is expanding rapidly, but not as rapidly as we would hope. In Europe, we see Germany is moving along fairly progressively, while other countries just next door, say France, is not at all. And so I think from the trend for medical cannabis will be continued to grow and expand, but not as rapidly as we want. Meanwhile, some of these novel cannabinoids, you mentioned CBG, non-psychoactive, CBN, which may or may not, depending on the studies that you're reading, promote sleep. And there's Delta 8 THC, which is the brand new hot cannabinoid on the market in the United States, and in some countries that would be legal under their controlled substances laws, and other countries that wouldn't. And so all that is to say, I think the novel cannabinoids piece is going to really advance over the next 18 months.
Absolutely. Yeah, we have seen that a lot here in California, and I'm interested to see where it goes beyond. So anyways, great to get to know a little bit about your background. I'm going to go ahead and stop sharing my screen, and then can you go ahead and put your presentation up?
Yeah, let's see if I can make this work. So hit share screen and find my my PowerPoint. Well, where did it go? There it goes. And of course, it's the bottom one here. Okay, so can you see that okay?
Yep, that looks good.
All right, so let me get back to the one here. So I apologize. I'm just trying to, there we go. Okay, so there's the starting one. This is my bio, which we've gone over, and I've also spoken to. So we'll kind of get started. Driving while impaired by cannabis is not a new issue. However, in the wake of the current marijuana revival, and I'm using that term, that's a term of art, by the way. Marijuana is the term that's used by the statute. So it's a term that I'll often employ to distinguish between cannabis that is unlawful at the federal level versus cannabis that's lawful at the federal level, which we call hemp in the United States. Anyway, in the wake of the current marijuana revival, in which patients and non-patient adults have more access than at any time in recent history, the issue of cannabis impairment and driving is rapidly coming to the forefront. A 2017 National Survey on Drug Use and Health study reports that after alcohol, marijuana is the most widely used drug in the U.S. 44% of the population aged 12 years or older report having used it at least once during their lifetime, and 9.6%, so almost 10% of the population report using it within the past month. Today, I'm going to discuss some of the legal issues surrounding cannabis as it applies to driving. And then after my presentation, of course, I'm happy to answer your questions. I will say I'm a bit nervous about responding to technical questions from a bunch of scientists, but I will definitely do my best. All right, well, I think to start with, it's important to note that there are 3 distinct types of cannabis legalization that have been enacted at the state or local level in the US since it's federally illegal. So first we have decriminalization. Since 1972, 22 states and DC have enacted varying policies decriminalizing small amounts of cannabis. These range across the board. There's no really sort of set framework for what decriminalization means, other than that it means reduced penalties from what they were. So that can mean getting what amounts to a citation, to just that the charges might be a misdemeanor where formerly they were a felony. We really get to talk about progressive policy. We move into medical cannabis. And since 1996, with California's law, 33 states, DC, Guam, and Puerto Rico have enacted varying laws permitting comprehensive medical cannabis programs. I use the term comprehensive. I'm, of course, pulling this data from various sources. With medical cannabis, when we think about that, we typically think of, well, you go see your doctor, you get a recommendation, and then you take it to a licensed dispensary where there's an array of products that you can use, and you actually have an affirmative right to use that cannabis. But it can also mean other things. It can mean that if you have cannabis with a doctor's recommendation, that you can be charged with a crime, but you can then use your cannabis recommendation as an affirmative defense to that crime, which is not perfect by any respect. It can also mean there are laws in the books that allow CBD oil with THC concentration slightly above 0.3%. My state actually has one of those, despite the fact that we're a prohibition state. So these laws vary widely, but medical cannabis laws, the more comprehensive ones, are beginning to win the day. And then the last form is the non-medical adult use cannabis legalization, sometimes referred to as recreational use, which is a term that I typically don't use. But since 2012, 10 states and the District of Columbia have enacted varying laws permitting small amounts of cannabis for non-medical adult use for adults that are 21 years or older. These various regimes that I've talked about, decriminalization, medical and non-medical adult use, have little to no relation whatsoever to cannabis impairment as it relates to driving, which is one of the problems right off the bat, that these laws regarding cannabis don't really typically aren't connected to the laws regarding impairment itself. But regardless of how their specific laws classify cannabis, from it being an outright crime to being completely lawful for people aged 21 and over, all US states and the federal government have laws prohibiting driving while impaired, including by cannabis. And as with most things in the cannabis sector, the laws that address it differ widely between these jurisdictions. Broadly speaking, regulations regarding driving while impaired by cannabis can be divided into 4 categories. The first category is zero tolerance. And this means that driving with any detectable amount of delta-9 tetrahydrocannabinol, THC, which is of course the primary intoxicating compound found in cannabis, or its metabolites in the body, is a criminal act. There are 12 states currently that have zero tolerance laws. The next type of regime is what we call per se. And this law, or this type of regime, prohibits driving with a detectable amount of THC that exceeds a predefined legal limit. 6 states currently have per se laws, although the legal limits for what constitutes a per se violation vary pretty greatly between them, from 1 to 5 nanograms per milliliter. And this refers typically to blood or plasma. The third type of regime is what we call DUID, or driving under the influence of drugs regulations. These regulations prohibit driving while actually impaired by THC. 32 states and the federal government have adopted a driving under the influence of drug law. It's best illustrated by a recent Massachusetts Supreme Court case called Commonwealth versus Gerhardt. In the Gerhardt case, which I'm summarizing based on a 2019 report by the Massachusetts Cannabis Control Commission, very good report, by the way, that I highly recommend, the defendant driver was charged with operating a motor vehicle under the influence of cannabis. The defendant, the driver, filed a motion challenging the admissibility of evidence concerning his performance on field sobriety tests that were conducted after the stop. The Massachusetts Supreme Court held that a prosecution for operating a motor vehicle while under the influence of cannabis, law enforcement officers may not testify to the administration of and results of field sobriety tests as they do in operating while under the influence of alcohol prosecutions. However, they may testify through the administration of roadside assessments, and that a lay witness may not offer an opinion that another person is high on cannabis. A police officer may testify to observe physical characteristics of the driver, such as bloodshot eyes, drowsiness, lack of coordination, but that officer may not offer an opinion that these characteristics mean that the driver is under the influence of cannabis. And jurors, in the event of a jury trial, may utilize their common sense in deciding if a driver's performance on the roadside assessments indicates his or her ability to operate a motor vehicle safely was impaired. So from a practical standpoint, under this Gerhardt decision, a law enforcement officer may testify about these observations that he or she made during the administration of roadside assessments to the extent that they're relevant to establish a driver's balance, coordination, mental acuity, and other skills that are required to safely operate a vehicle. However, and this is really important, an officer may not testify on direct examination that a driver's performance on one of these assessments established that the driver was under the influence of cannabis or that that driver passed or failed an assessment. I'm going to talk about these field sobriety tests in a few minutes in my presentation, but I thought it was important because of the different types of regimes that states and the federal government employ to determine when someone should be charged with a crime for driving while use of cannabis. This is the only current regime, the DUID, that tries to get some objective data based on impairment versus a biological proxy, which I'm going to delve into in a few minutes. The last type of regime is a reasonable inference. This is fairly unique in that it's Colorado is the only state that's adopted it, but it's a rebuttable inference of criminally sufficient impairment if a driver's blood contains THC that exceeds 5 nanograms per milliliter. And so what that means from a legal standpoint is that it's sort of like the per se laws that if you have more than 5 nanograms per milliliter of THC in your blood plasma, you can be assumed to be impaired. However, the driver can present evidence that in fact he or she was not impaired. Before we get into talking about these various tests, I think a threshold issue to consider, the one that's perhaps the most important thing we're going to talk about, is whether cannabis use actually functionally impairs driving ability, and if so, to what degree. And I think the listeners here may be surprised to hear that this issue is not settled. Unlike alcohol, which causes predictable functional impairment among all drivers, cannabis does not impair all drivers, and nor does it impair all drivers equally. A 2009 paper called The Effects of Cannabis Compared with Alcohol on Driving, which reviewed a number of clinical studies, found that, and I'm quoting here, most marijuana intoxicated drivers show only modest impairments on actual road tests. Experienced smokers, they were assuming that all cannabis users were smokers at the time, this is 2009, but experienced smokers who drive on a set course show almost no functional impairment under the influence of marijuana, except when it's combined with alcohol. A National Highway Traffic Safety Administration report that was submitted to Congress indicated that, quote, subjects dosed on marijuana showed reduced mean speeds, increased time driving below the speed limit, and increased following distance during a car following task. And so this and a number of other studies reveal that, after smoking marijuana, subjects in most of the simulator and instrumented vehicle studies on marijuana and driving typically drive slower. They follow other cars at greater distances and take fewer risks than them when they're sober. And so because of the complex ways in which cannabis interacts with the body, it affects individuals differently based on a number of factors, including their height, their weight, their sex, their method of use, and importantly, their frequency of use. While an experienced cannabis user may not be impaired at all by cannabis use, an inexperienced user may be impaired significantly by using even a relatively small amount. And evidence shows that not all drivers with THC in their blood plasma, even at per se impairment levels, are functionally impaired. The timing of cannabis psychoactivity and its onset is affected greatly by its mode of use. Smoking cannabis has rapid effects that can be felt within minutes. And I'll note that vaping has similar effects that may be slightly slower than from smoking, but by and large, it's similar to smoking. Cannabis effects correlate with THC levels in the brain, but these levels cannot be measured effectively. THC can be measured in blood and oral fluid rapidly after intake, but peak levels drop quickly despite its continued effects due to its fat-soluble properties, which I'm going to address in a moment. With respect to edibles and other oral doses, they have significantly delayed effects compared to smoking and vaping. Absorption occurs more slowly, and the amount of THC absorbed varies based on what has previously been consumed. So moreover, the primary intoxication is due not to delta-9 THC, but to 11-hydroxy-THC, which is a psychoactive metabolite of delta-9 THC. As I mentioned earlier, that's the active psychoactive component in cannabis. 11-hydroxy-THC has been shown to produce deeper and more prolonged effects than inhaled cannabis. Also, consuming the edible on an empty stomach results in greater effects because the proportion of THC to other byproducts is larger. And then finally, sublingual and other modes of using cannabis differ widely as to the onset and the timing of the effects. In a recent paper by Terry and Adrian Moore called "It's High Time, A Common Sense Approach to Marijuana Impaired Driving," they stated that unlike alcohol, which is hydrophilic, cannabis is lipophilic. It's stored in the fatty tissues of the body. And this characteristic means that cannabis compounds, including the psychoactive 1-THC, store and are detectable long-term up to a month or longer after abstinence, as THC leaches into the bloodstream from fatty tissues. And blood plasma levels and impairment vary greatly in subjects given the same dose. And so, although most of the literature on cannabis testing in cars or even in the workplace focus on false positives based on cannabis's lipophilic properties, meaning that, as I just said, it's absorbed into our fat cells, and so we can test positive, meaning show that there are THC or its metabolites in our body, despite the fact that we're not impaired at all. Another property or another result of this this lipophilic quality of cannabis is that not all cannabis impaired drivers test positive for THC. In other words, there are drivers on the road at times that are impaired by cannabis, but a plasma test would not show them as being impaired. And this is due to the fact that peak impairment, which typically occurs 90 minutes after smoking, coincides with an 80% drop in THC levels in blood plasma. Thus, low THC levels may not be a reliable indicator of recent cannabis use. And so accordingly, the 6 states that rely on per se levels are likely to release drivers with below per se levels who are still impaired. And per se THC blood levels do not track with impairment. Blood tests can only show that cannabis has been used within some relatively recent period, meaning 2 to 4 weeks or more. And studies have consistently shown that blood plasma tests are not reliable indicators of impairment, since they can only show that cannabis has been used within the past several days or month, rather than within the past, hour to 3 hours of driving. With respect to urine tests for cannabis, they're actually worse. They do not test for THC, which is the most active intoxicating compound in cannabis, of course. Instead, they test for carboxy-THC, which is a non-psychoactive metabolite produced by the liver in response to THC. In other words, it detects the presence of a non-intoxicating compound to determine if cannabis has been used. So as a lawyer, I'll say that this poses an immediate issue regarding the determination of whether one is impaired. Because if the only compound that's identified in the test is non-psychoactive, how can it demonstrate impairment, particularly if the compound is produced in different volumes by different people and is sensitive to the mode of ingestion and also a number of other biological factors? The window of detection for cannabis use in a urinalysis, much like plasma, is wide. Depending on the subject, it can trigger a positive result for cannabis use during the prior 3 to 30-day period, which of course has little to any relevance for determining actual impairment at a given time. Furthermore, with respect to post-mortem analysis for THC, it is not a reliable indicator of pre-death impairment. For instance, if someone dies in a traffic accident and they do an autopsy looking for THC, that is not a reliable indicator that the driver of that car, who's now deceased, was impaired. This is because after death, the body begins to break down, and the cumulative THC that's stored in fat cells is released into the body. So for this reason, every post-mortem analysis of THC shows hyper elevated levels of THC, and they're totally meaningless for developing DUI policy generally and specifically per se limits. As a result of an extensive study, the American Automobile Association Foundation for Traffic Safety concluded that a quantitative threshold for per se laws for THC following cannabis use cannot be scientifically supported. Recent advances in other testing methods, including a breathalyzer, claim the ability to determine if an individual has smoked THC in the past 2 to 3 hours. That system collects 5 minutes of exhalation, and I'm referring specifically to the Hound Labs system. And by the way, I don't represent or have an interest in Hound Labs. That system collects 5 minutes of exhalation onto a silicon bead module, dissolves it in pure ethyl alcohol, and then sends it to a fluorescence-based chemical assay for analysis. Readout is in picograms per liter of breath. And while this may be a useful tool for law enforcement, it still does not prove impairment. Rather, again, as with the other tests, it relies on a biological proxy for impairment, despite there being no proven general correlation between cannabis use and functional impairment. And additionally, no state laws currently set limits for THC on the breath or a time-based determination to confirm impairment. All of this is to say that the notion that impairment can be assumed or not based solely on specific concentrations of THC or its metabolites in a driver's blood or urine is plainly wrong. The problem with tests that measure THC or its metabolites in the body is that they all rely on a biological proxy for impairment, when no such proxy appears to exist, regardless of the type of test. So that begs the question, what about standards that do not rely on a biological proxy? Colorado is the first state to legalize cannabis for recreational use, defines DUI for an individual when they are, quote, substantially incapable, either mentally or physically, or both mentally and physically, to exercise clear judgment, sufficient physical control, or due care in the safe operation of a vehicle. Now, this is a useful definition of impairment that has no correlation to specific quantities consumed or how recent the consumption occurred, and fully supports the argument that impairment testing is the most useful method for determining THC influence. Current evidence suggests that regulatory approaches to driving while impaired by cannabis should be geared towards removing impaired drivers from the road while not unnecessarily criminalizing non-impaired drivers who use cannabis legally. Zero tolerance and per se regulatory approaches are ill-suited to supporting this policy goal as they're not reliable measures. Additionally, both approaches have a great capacity to criminalize individuals who are not impaired, but who have THC or its metabolites in their blood or urine. And in fact, both approaches almost certainly violate the due process clause of the 14th Amendment of the U.S. Constitution because they subject drivers to criminal prosecutions without any real culpability. And although Colorado's permissible inference approach does not violate the due process clause, the fact that it still places the burden on the driver to prove that he or she was not impaired is overly burdensome, if not philosophically impossible, to prove a negative, and certainly unsupported by relevant data. And this is complicated by the legalization at the federal level and at most state levels of hemp, which can legally have up to 0.3% THC. So someone who is using a form of cannabis that's legal at the federal and the state levels can still build up THC or more importantly, metabolites to that THC in their bodies, completely unimpaired, but may test positive for THC in a roadside test. So approaches that do not rely exclusively on blood or urine tests to determine impairment are clearly better suited for removing impaired drivers from the road while ensuring that the constitutional rights and arrest records of unimpaired drivers remain intact. So ultimately, of course, the issue is impairment, not what or how much of a particular substance a driver has ingested. Because in fact, fatigued drivers can be lethal drivers despite not having used any substances, legal or not. Non-biological approaches to determine impairment by the use of non-qualitative field sobriety tests are probably the best methods, at least that we have now. Because field sobriety tests evaluate divided attention skills, they provide fairly accurate assessments of driving impairment, no matter what substance the driver may have ingested. In the case of cannabis, a driver's failure to perform a field sobriety test is demonstrated, combined with a THC positive reading on a roadside testing device, can often, not always, but can often, excuse me, provide adequate reasonable suspicion for further investigation or more typically a probable cause for a DUI arrest. So let's talk about the standard field sobriety test. It's the most common example of a test that a law enforcement officer would give to a driver that he or she believed was impaired. In a standard field sobriety test, An officer administers, observes, and scores a driver's performance on a series of 3 tests that are performed roadside during a traffic safety stop to assess a driver's impairment and probable cause for arrest. The tests include first the horizontal gaze nystagmus, the walk and turn test, and the one-leg stand test. And I'm going to address each of these briefly because I think that's important. First, the horizontal gaze nystagmus test is typically conducted with a suspected driver standing, feet together and arms at the side, and requires the driver to follow the movement of a stimulus with his or her eyes. The officer will observe the effects of the stimulus movement, speed changes, and location in both eyes. Excuse me. Among the 3 tests included in the standard field sobriety test, this one is most often inadmissible in court, meaning it's not usually admissible in court. A major factor is that this test does not take into consideration mobility problems that a subject may have with his or her eyes. The second subtest in the standard field sobriety test is the walk and turn test. In the walk and turn test, the suspected driver is directed to take 9 steps, touching heel to toe along a straight line, turn on 1 foot completely, and follow the same instructions in the opposite direction. The officer observes 8 indicators of impairment, including the driver cannot keep balance while listening to instructions, begins before instructions are finished, stops while walking to regain balance, does not touch heel to toe, uses arms to balance, steps off the line, takes an incorrect number of steps, and makes an improper turn. As you might guess, these can certainly demonstrate impairment, but they can also demonstrate anything else. You know, as a lawyer, sometimes, for example, I just plow into things without listening to instructions, and I'm sure a lot of us that are listening do the same thing, and that's an indicator that someone may be impaired. Also, different people have various baselines for balance. Which leads us into the third subtest on the standard field sobriety test, which is the one-leg stand test. In this test, the driver is instructed to stand with 1 foot approximately 6 inches off the ground and to count aloud by ones, beginning with 1,000 until told to put the foot down. So you might stand there and say 1,001, 1,002, 1,003 for 30 seconds. And during this time, the officer observes 4 indicators of impairment. 1 would be swaying while balancing. 2 is using arms for balance. 3 is hopping to maintain balance. And then 4 is putting his or her foot down. And as reported by the Massachusetts Cannabis Control Commission, there are varying limitations to these tests and reasons that are unrelated to substance use where a law enforcement officer may designate impairment for a person on a particular test when that person is not actually impaired. So for example, and as I referenced earlier, a driver who has an eye disease or a condition that affects his or her ability to see could confound the test, and the results of the test, his or her age, disability, injury, or disease could also affect the ability of a person to perform the one-leg stand test or the walk and turn test. And additionally, persons with certain physical and or mental health disorders or disabilities may be unable to successfully complete these tasks, whether they're impaired by substances or not. Generally speaking, the use of most field sobriety tests as a more reliable indicator of impairment than biological tests may be overly optimistic. The most important question is whether there is objective data supporting the same or at least similar levels of confidence for a field sobriety test to determine cannabis impairment as there is for it to determine alcohol impairment. And the answer appears to be no, or at least not always, which is why field sobriety tests in development specifically measure symptoms of cannabis intoxication, such as a slow reaction time, a misperception of time passage, an inability to handle divided attention tasks. In short, there is currently no parity between alcohol and cannabis intoxication, at least in terms of reliable methods for determining functional driving impairment. And whereas alcohol impairment can be reliably determined by the driver's blood alcohol levels and or a field sobriety test, the same is not true at all for cannabis. Additionally, and perhaps most importantly, field sobriety tests ultimately rely on a law enforcement officer's subjective evaluation and determination for impairment. In other words, so while they appear on their face to be objective, oh, we're running a person through a battery of tests, really they rely ultimately on the officer's subjective determination on whether the person passed or failed or how they otherwise performed on these tests. As I mentioned earlier, the standardized field sobriety test consists of 3 tests. 2 or more unsuccessful tests typically constitute a finding of impaired. But according to an extensive review of cannabis impairment and laws in a 2019 report by the Massachusetts Cannabis Control Commission, a study of medicinal THC in 2012 found that the standard field sobriety test did not accurately differentiate between cannabis and a placebo. This study found no differences between placebo, low, and high dose oral THC in the standard field sobriety test, despite observing differences in the driving simulator. In other words, the field sobriety test just didn't work when it came to cannabis. And then maybe the most important thing, particularly in light of the current political situation, while moving away from a biological proxy for impairment, field sobriety tests which rely on an officer's judgment are far from objective or consistent in determining impairment. Moreover, the subjective nature of such tests makes them particularly susceptible to civil rights violations, as an officer's judgment may be overridden by racist, sexist, and other inherent personal prejudices. To that point, Blacks and Latinos are arrested for drug offenses at disproportionately higher rates than whites, despite similar rates of usage and sales. In a comprehensive evaluation of state police data in 20 states from 2011 to 2015, researcher Emma Pearson and her colleagues in a paper entitled A Large-Scale Analysis of Racial Disparities in Police Stops Across the United States found that Black drivers were stopped at higher rates than whites relative to driver population, and Hispanic drivers are stopped at similar or lower rates compared to whites. Of cars that are stopped by law enforcement, Pearson found that Blacks and Hispanics were more likely to have a negative outcome, meaning receiving a ticket, being searched, or even arrested from such stops. A promising test that does not use a biological proxy for impairment and which does not use a field officer's subjective evaluation is the Druid app, which is installed on a phone or a tablet. And I'll say two things. One is that I do not represent or hold an interest in Druid. And secondly, my slide, as I prepared it, had some of the ways that Druid works on it. So I apologize. I'm not sure why it's not showing up. But I'll go ahead and talk about it. The Druid app currently measures impairment based on 4 tests, all that are performed via a phone or a tablet. First, a decision-making and reaction time test in which the subject taps a square or an oval on the screen. 2, a time estimation and reaction time test in which the subject taps the figures on the screen and estimates the passage of time. A hand-eye coordination test in which the subject follows a moving white circle on a screen and counts squares. And then 4, a balance test in which the subject holds the phone still while raising a leg for a period of time. When a baseline of the subject can be established by virtue of a prior Druid test, when the subject is sober, the test's accuracy is high. And I understand that determining impairment without the benefit of a baseline is based rather than on the individual, but on a composite of many individuals. And currently there are over 10,000 uses of Druid that are saved to its database. Oh, there's how Druid works. I'll just kind of click through those. So to conclude, I'll revisit the fact that there is sparse and contradictory evidence regarding THC concentrations and their correlation with cannabis intoxication and driving habits. In other words, the presence of THC or its metabolites in specific or even any concentrations in a driver's body is simply not a reliable biological proxy for impairment. In a paper that I co-authored with Dr. Jehan Marcu and Dr. Russ Pfeiffer, which informed this particular presentation, we concluded that impairment is the issue, not the concentration of THC and its metabolites in the human body. The use of THC concentrations alone, or the presence of metabolites in any fluid sample, to equate to an acute cannabis intoxication will continue to result in inappropriate arrest, prosecution, and civil liability. Indeed, given the fact that THC in blood plasma levels drop dramatically shortly after use, pursuing biological proxies for intoxication will also keep impaired drivers on the road. To this end, testing that focuses on impairment rather than the presence of THC in the body is the most appropriate one to achieve the dual policy goals of removing impaired drivers from the road while not criminalizing non-intoxicated drivers who lawfully use cannabis. And although far from perfect, field sobriety tests for impairment is currently the best and fairest option for determining whether a driver or even a worker in the workplace can safely navigate the road or be safely productive in the workplace, although the fact that it relies on a field officer's subjective evaluation is problematic for a number of reasons, including social equity. And finally, Druid and similar electronic tests, which test for impairment rather than THC in the body, and which mostly remove a field officer's subjective judgment, appear to be the most promising path forward for determining impairment due to cannabis ingestion and other things, such as fatigue. But unfortunately, state legislatures are far, far behind in this rapidly developing issue, and we'll continue to see approaches that are based on biological proxies and officer-conducted field tests for the foreseeable future. And that's my presentation. I'm happy to respond to questions and discuss this intriguing topic.
Well, thank you, Rod. Really enjoyed the presentation, and thank you for sharing your perspective on so many of these topics. So we do have a few questions to kick it off with. One that came to mind is, there's so much controversy over cannabis. A lot of this stems from stigma. So here's a related question. Is there, alcohol is an obvious one, but beyond alcohol, is there any other comparable substance where law enforcement is seeking to define an amount of the substance itself or a metabolite in the blood or the plasma or the breath of a driver, such as cannabis? So for example, I'm thinking we've had the opiate crisis. We have a huge level of benzodiazepine prescription. There's people who take hundreds or thousands of milligrams of caffeine at a time, all of these, and there's a whole realm of other over-the-counter substances. So there we go. So back to my question, is there, other than alcohol and now the same with cannabis, is law enforcement monitoring any other substance in drivers' bodies?
Well, I mean, I think that that's a great question, and the answer is yes, of course. I think the real issue is, are some of these other substances, do they have the same issue that cannabis does, whereas levels of these substances or their metabolites are being used as a biological proxy that relate directly to impairment or not. And the second is, and I think probably the most important piece, is that, cannabis is the low-hanging fruit. And so, and there are a lot of issues involving social equity and civil rights and the use of cannabis that are not directly related to impairment here. But yes, there are drug recognition experts, and there are all sorts of programs that law enforcement officers can take to learn how to determine if someone is impaired, and if so, what they're likely to be impaired from, so that then they can determine whether or not they have probable cause to arrest the person, and then maybe have that person subjected to certain types of blood or breath or urine tests to determine what that substance is, whether it's methamphetamine or cocaine or cannabis or alcohol or some other drug. But the bottom line is that cannabis use is being watched for, and law enforcement officials, if they smell cannabis in a car, will often say, "Oh, this person's been smoking cannabis." That's going to affect their judgment on the field sobriety test, and these people are going to be charged with a crime where they may not be high at all. The car may not have cannabis in it, or it might have hemp, which is legal. So there are a lot of issues that are playing out.
Yeah, that can be confounding with the hemp thing. So, and I guess to clarify on my former question, that I fully understand what you're saying about law enforcement being interested in a range of substances, but I guess my direct question was, so far as in the moment, if let's say officers to pull over a driver, and for example with the alcohol breathalyzer, or we're talking about this Hound Labs cannabis breathalyzer, is there anything or any of these other substances where they're seeking to know right then and there about the substance or the metabolite in the system?
Not that I'm aware of. I mean, again, I think that these DREs, the law enforcement officers that are trained to identify drug use by drivers, my guess is, and I don't have a lot of information on this, that they are aware of other symptoms. If someone seems super jacked up, for instance, they might say, "Oh, well, this person might be on meth, or they might be on cocaine," and so they follow a protocol. But in sort of wide scale, is law enforcement looking for people that are impaired on these things? I think the answer is no, unless they're just obviously impaired. And
Yeah,
the
I
same is
think
not true for alcohol or cannabis.
right, and I think I guess the reason I wanted to just bring that up is because you showed and statistics are always interesting that I think it was 44% of adult Americans had used cannabis in the last year, 9+% had used it in the last, was it week?
So it's
Or
44% in a lifetime, which, you know, that can be
I see.
people that tried it in college and they're in their 60s. But I think that the statistic that it was almost 10% had used it within the past, I think it was month. I'd have to go back through my slides. But
No,
within a period of time that would trigger a positive result on a plasma and or a urinalysis screen, whether they were
I
impaired or not. Exactly. And that's 10%.
I
That's 1 in 10 drivers on the road. Potentially, there's not a direct correlation between people and drivers, but you know what I mean? Generally speaking, it's a big percentage of people.
understood. And then just to go back to the reason I asked that question is what percentage of adult Americans are taking a pharmaceutical or an over the counter that may alter their ability to drive. So anyways, I won't harp on that too much
Absolutely.
longer, but it's a stigma is a real issue and it's a point I wanted to make. So
It's a major issue, and I think you're right on point with that. Absolutely.
oh, I'm glad we're in agreement. So anyways, here's another interesting question. So cannabis and cannabis legalization is blossoming around the world. So, and you work in multiple jurisdictions. I'm curious, do you have any insights into how other countries or other jurisdictions, even maybe a place like Canada where it's federally legal, are tackling this issue? Do they have the same stigma? Or are they using a similar testing regimes? Do you have any insights there?
So I don't have any specific insight or knowledge of the frameworks that are being used in Canada or other countries, but I have come across it in my business work, and the stigma is there. I have to say, cannabis stigma is real, and it exists pretty much globally and to varying degrees. And the ways that we're approaching it in most countries is kind of the same. And that is, we're used to a situation. Alcohol is sort of the number one thing when we think about DUI. We think about, okay, someone's driving under the influence of alcohol. We pop them on a breathalyzer or get a blood test, and bam, we know. And we know if that result is X, then we can confidently say they were impaired. And so that's the mindset, and that's the way the laws are being written and the regulations are being written. And as I've hopefully demonstrated, that is absolutely the wrong-headed way to go about this. But it requires an understanding of how cannabis affects the body and how it affects different people, and it requires legislators and regulators to dig in. And unfortunately, that doesn't always happen. In fact, in this situation, it rarely happens. And so what's been done before is often what gets done in the future, regardless of its efficacy to addressing this specific problem.
Totally, and I appreciate you bringing that up, and it actually segues nicely into what I was gonna bring up next, which is that it's exactly what you said. What happened before often just continues to happen, and as you're giving your presentation and making this excellent point about the biological proxy, is that in fact, so I guess the point that I want to make, and I'm curious for your feedback, is that often with we think as scientists, myself included, that there's always a scientific solution. There's always a test, and it's I think it's this combination of the historical combined with the confidence of the science realm. And I can't, and I think it's very interesting for folks like Hound Labs and for Druid App to be working towards this, and that's what scientists do. They work to solve these solutions. But if in fact the biological proxy is going to be an issue, which it seems like it is, maybe the role of science in this case is to educate the lawmakers and the law enforcement about the way that cannabis works in the human body and the way that it's differential from something like alcohol. So to ask a direct question, what are your thoughts in that realm about education so what can scientists and the informed cannabis community at large do to help educate lawmakers and law enforcement about the potential realities of the situation?
Well, I think education is absolutely key. And I think, despite the mass media, saying that we're no longer a society that relies on science, I think we do. And I think people trust science, and particularly when science appears to be coming from a true sort of third party, these are just the facts. We're not pushing a particular product. And I think education is key to helping inform policy, and not only education about how we could be putting people who are who are not impaired in jail. That's atrocious. But also how based on these same tests that we're using and these same regulations and standard, we could be letting people who are impaired drive off, because of the way that THC is metabolized in the blood. It may not show up on a plasma test when the driver could be completely stoned. And so I think it's important to present that data and present it in a way that informs the regulations at issue. And so I think that's important. But also, you talk about the test, and sometimes with science, it's not about can we make, it's still about the test. So for instance, right now we're all, there's a lot of people that are in groups that are focused on better tests for detecting THC in blood or urine or our breath or some other measure. Well, if we've decided that a biological proxy is not going to work in this situation, well, then maybe there's a different test. And that's where the field sobriety tests come in. But of course, there's problems and issues with subjective and judgment of the officer. And then there are these apps like Druid, which appear to remove most of that subjectivity. And so it's truly objective. And in that case, it's more about, if this is the approach we want to use, can we develop the best and most accurate test model? So I think science is still involved, not only in education, but also in devising tests that really work and serve the policy goals at issue.
Totally, and I appreciate that. And what I guess I was referencing about education was along the lines of what you were saying, to have the states understand the kind of multiple layers of issue that you mentioned. So one last question here is, from your perspective, are there any states or jurisdictions that are kind of leading the way or setting an example that you might point to, or do you have any kind of, or if not, do you have any kind of final recommendations before we end our session?
Sure. I think that, in most things cannabis, Colorado appears to be leading the way. It does have this, it's the only state that has this rule that there is a sort of a per se, if you have more than 5 nanograms per milliliter of THC metabolites in your plasma, then you are assumed to be intoxicated or impaired for driving. But the key piece here is you have that rebuttable presumption. So you can rebut that by offering other evidence. It's far, 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 far from what we need. But at least it's beginning to focus on actual impairment versus just using this biological proxy that we've talked about.
Totally. And, I think kind of summing thought that I'm having coming out of this session is that this is really just the tip of the iceberg for the scientists, the chemists, the neurobiologists, and so forth in figuring out this issue. And it'll be really interesting to see where it goes from here. So for now, I'd just like to thank you for joining us at CANN Journal Club and for sharing your perspective. And thank you to, once again, our sponsors and for the audience for joining us today. And we'll be back with you next month.
Thanks for having me. I appreciate being here and enjoyed it.
All right. Talk to you soon, Rob. Thank you. Bye.